whose chairs have a mind of their own, I'm afraid. Yes, Mr. Cornwall.
My lady, I now move on to my final stage of my submissions, which is to address the three grounds. So the first ground is that the Upper Tribunal materially erred in law and was wrong in taking into account resources derived from the social assistance at all when determining what resources were available to WV when assessing whether he is a self-sufficient person for the purposes of Article 7.1b. So this is straightforwardly a misdirection of law point. The judge thought that he was bound by a string of Court of Justice decisions. In my submission, he was not, and he misunderstood and misapplied that line of cases. And there are basically four main points that I want to make, plus a couple of, as it were, ripostes to points that the judge makes in the judgment. And here I'm broadly going to follow the course of paragraphs 42 to 55 of my skeleton argument.
Thank you.
So we say that, correctly understood, it's quite consistent with the Court of Justice case law, and indeed is a proper interpretation and application of the directive, that in the particular circumstances of this kind of case, where the claimant, where the EU citizen substantially lives off social assistance provided to a family member, it is entirely legitimate to look to the ultimate origin of those resources, i.e. the state social assistance system, and consider that those either must be ignored, or at the very least the question is not whether the person has sufficient resources, but whether they are imposing an unreasonable burden on the social assistance system. So the first point we make, and I think this has already been trailed fairly extensively in my discussion of the case law, is that whilst the case law certainly establishes an EU citizen can rely on resources provided by various family members, none of those cases, critically, were ones where the relevant resources of the family member were themselves derived from state welfare benefits, still less from social assistance. Indeed, in a number of the cases, the court or the Advocate General specifically emphasises the fact that the claimant in question and their family were not, and there was no expectation that they would, ever become a burden on the social assistance system. For example, in Badgerateri, the Advocate General indeed made frequent references to the fact that Mr. Badgerateri was paying taxes and national insurance while working. So the Court of Justice simply didn't have in mind, when it made its fairly sweeping statements, the kind of issue that we have here. Second point is that just looking at Article 7.1b, it is clear on its face that there has to be some regard to the source of the origin of the relevant resources. On its face, it would appear to exclude reliance on resources that would amount to a burden on the social assistance system. And indeed, we now understand through the interpretation of the case law that that actually means an unreasonable burden, but nonetheless, the point is still stands, that one has to at least have regard to whether the resources are derived from social assistance.
There's a very straightforward way to interpret the provision, isn't there? Which is, you ask, in our case, is V claiming social assistance benefits? In many scenarios, that will be the case.
That will be the obvious, but in this...
Exactly. So why do you have to ask, in a case where V is not the claimant, for social assistance benefits? Why do you have to ask, where does the third-party source of funding come from?
Because there's two reasons why. One is because the funding, the amount of benefit paid was in part determined by reference to V and his membership of the household. So it wasn't as if he was a stranger to this arrangement. So although the money, the check, probably isn't checks these days, but the bank payment would have gone into second respondent's bank account. In my submission, it's artificial and not a proper purposive interpretation of the European provisions. Just to say that the fact that it's going to a different bank account is determinative here. So that's the first point. And the second point is the one of substance, that there is simply, as the tribunal correctly accepted, V is essentially, was in substantial measure, living off social assistance. So,
I know that's your argument, but all I was asking about was where I find in the text of Article 7.1b that one inevitably has to ask that question. That's the submission you were making.
Well, it's because in my submission it comes from the definition of social assistance that the courts adopted, the wording of Article 7.1b, and also what is meant by family member, and I'll come on to that under my ground too. I think that in my submission the judge was wrong about family member, and taking those all together in my submission, that's that gives you the answer.
Right, thank
you. As part of or connected to that second point that I was making, I've now become good on my promise to point out the relevant passages in VP, which we looked at on another point before lunch. That's at tab 13. Sorry, tab 12. From paragraph 87 onwards through to 97, the judge analysed in that case the question of whether the fact that the origin of the resources that VP was relying on was his own work, albeit outside the A8 registration scheme, meant that he could rely on those resources as the basis for self-sufficiency, and concluded that it could not. And he expressly recognised at 88 the case law in Commission in Belgium about caution about looking at the origins. But in that case, he quite properly, in my submission, considered it necessary to look at the origin of the resources in order to give proper effect to the structure and purpose of the directive, which in that case was undermined by, as it were, muddying the water between the economically active and inactive. And in my submission, the same approach applies here, the same kind of approach. My third point under this heading is that Article 7.1b requires sufficiency of resources for the EU citizen and their family members. J was in receipt of welfare benefits. She was therefore quite lawfully and properly a burden on the UK social assistance system, given the way in which social assistance is defined in Bray at 61. That's a definition which is essentially neutral as between host state nationals and EU migrants. Indeed, in my submission, there's the confirmation from the Court of Justice that it is permissible to consider both nationals of the host state and EU migrants as being a burden, and one sees that from the very last case in the bundle, GV, tab 33. Messed up my reference there. Okay. Sorry, I will try and find that. There's definitely a case in which the court recognised that a host a national, the host state can be a burden, and if J is a burden on the UK social assistance system, then it must necessarily follow that V, relying almost entirely on her resources derived from her benefits, was also a similar burden. Related to that point on burden, it is the point about whether the burden needs to increase or not. In my submission, there is nothing on the face of the directive or its interpretation in the Court of Justice cases that requires a burden to be increased. The question is simply whether someone is dependent on social assistance in circumstances where they otherwise can't meet their needs. Whether or not that there is an increase or decrease or no change at all is, in my submission, beside the point, though the position may be a fortiori if the addition of an EU migrant citizen to a household increases the level of social assistance.
How does that square with what you've been showing us as the rationale and the purpose of Article 7, which is, isn't it, that there must be some connection between the economically inactive migrant coming here and the circumstances of his residence and the burden on the social assistance programme?
Well, the starting point in my submission is that, as it's clear from Article 7, that to have Article 7 rights, one needs to be able to provide for oneself, either through work, or through self-employment, or by being able to meet self-sufficiency conditions.
Well, that's sorry to interrupt you, but that's a reformulation of what the actual test is, which is you need not to be a burden on the resources, the social assistance resources of the host state. And that then begs the question as to whether that means not a burden at all, or not creating a burden by virtue of your residence.
You have to have resources, and the question is whether those resources are a burden on the sufficient to avoid you becoming a burden on the social assistance system of the host state. That if the resources that you have in order to live are indeed sourced from the host member state's social assistance system, then submission, they are. You are a burden. That's a perfectly natural reason.
I understand you say. I understand you say that's the effect of what it is, but I'm just asking about the rationale, which seems to be that it's trying to stop people, a certain category of person, coming to the host state, and by reason of their coming here and being resident here, thereby imposing a burden. And if the net effect of their being here is that the burden on the state social assistance system is not affected, it's the same, how does your submission fit with the rationale?
Well,
that's what I'm asking you.
In my submission, it fits with the rationale, because as Judge Ward himself suggested, he considered this was a very rather unusual set of circumstances. The broad category of cases, if someone turns up in circumstances like Mr. Versnick's, where he was economically inactive and had effectively no resources, then he's going to be he's generally going to increase them.
Well,
now,
other cases may be different. I quite understand that if we're with you with almost everything you've said up to this point, you can take into account the indirect origin, and if it were the case that by him joining the household and being included in the calculation, the social assistance provided to Jay was greater than it would have been had she been living alone, then the point that we're on wouldn't arise. But because of the facts of our case, it does arise. The social assistance has gone down, despite the fact that it's calculated on the basis of his presence as well as hers. And they may be very unusual facts, but they're the facts we've got to deal with.
Well, yes, I appreciate that, but I mean, I think I'd make 2 points. One is, I go back to the point that that the correct approach and correct starting point is to ask, when Mr. Versnick turned up in the UK and you asked if he'd been asked, if we had had a registration system and we carried out the exercise that Judge Ward identifies in the VP that I took you to earlier, saying, right, how are you going to have a right to reside? He says, well, I might one day seek employment, I might do a bit of self-employment, haven't got any immediate plans, but otherwise I'm going to live off my wife's benefits. In my submission, that is plainly a case of putting a burden on the social assistance system. I mean, that is, he's not saying I have any resources of my own. I've not got my wife materially. I think there were £1,000 of savings in the family, but basically there are no savings. This is what I'm going to live on. In my submission, ultimately it doesn't matter whether or not he actually increased the amount of social assistance going to the household. I think I do say that on sensible view is sufficient for a burden.
I understand. And if the question that he'd been asked is, are you by coming here going to impose any burden on the social assistance system, his answer would have been, well, I'm going to live off my wife's benefits, but don't worry, that's not going to put any burden on it. She's not going to have to claim any more than if I weren't here.
Well,
it all depends how one frames the question.
Yes, I can see that, but yes, I go back.
Did you say that's the first question?
Looking slightly at the wrong end.
Essentially, has he got sufficient resources? That's the focus.
Yes.
Can I just ask a follow-up to that scenario? speaking for myself, I found it helpful when you posed the registration system hypothesis. So suppose the UK had a registration system, V arrives in the country, and he's asked how he's going to survive, in other words, how he's going to meet his basic needs. And suppose the answer is, well, I've got enough for myself, but I haven't got enough to support my family members, in other words, J.
Yes.
I think if I've understood your submission correctly, you say that even in that scenario, he falls foul of 7.1b because J is his family member.
Yes.
And he has to have sufficient resources, not only for himself, but for his family members, not to become a burden.
Yes. I'll come on to that. I was going to come on to that on ground 2. But yes.
But
I mean, the family needs to have.
Yes.
If J is going to be the source of resources, and the resources she gives to him, she needs to have enough resources to live herself.
No. That's why I'm posing. I know it's not the fact of this case, but I just want to test what your submission is. That even if he does in fact have sufficient resources to support himself, you say that he still falls foul of 7.1b because he doesn't have sufficient to support J.
Well, it depends. Right. I think maybe one needs to clarify the scenario that you're putting forward, because is it a case where J also doesn't have enough resources?
Well, J is doing what she's been doing for years,
right?
Which is living off the UK's social assistance benefits.
Yes.
So her own situation has not changed at all. What's changed is that V has come along, exercising his free movement EU rights, and the question is, does he fall within 7.1b? And
yes.
I'd just like to know what your submission is.
If in that scenario he has a certain amount of resources, but they're not enough to cover, or when you take into account the resources that J has.
Yes.
Yes.
Yeah.
Yes. That's.
I thought that was
it needs to be looked at collectively.
Yeah.
Have they got enough? Because otherwise, the sort of idea that they can divvy them up so that the EU citizen has enough resources to say they're self-sufficient, and completely ignore, as Judge Ward seemed to suggest, completely ignore what might be left over for the British national, who is the source of the resources, or the conduit of the resources. If that's not putting it too tendentiously. Yeah, and that's.
So would you go so far then as saying that the migrant coming in would not only have to have sufficient resources for himself, but to get within Article 7b, would also have to have sufficient resources in order to take his wife off social assistance? And if he didn't have enough resources to do that, then he doesn't get home. Applying that to the facts to this case, is that the logical conclusion of where you're going? Only unless he has enough himself to take the family off benefits, treating care allowance obviously separately, he has no right of residence.
No, I don't think I think that scenario.
So why not? Where's the difference? Where's the trip switch?
I think the answer. Yeah, I can see the point you're making. I think I go back on what I said earlier. Actually, that logically, yes, I think that would be the conclusion.
Yeah.
I'm not saying it's right or
No,
wrong.
but
I'm simply trying to follow it through.
I think that would be. I mean, insofar as the benefits were social assistance and were resource related. I mean, it may well be. Yes, I mean there are various ways in which a couple could stop being eligible. They could either exceed the capital limit, or they could exceed the income limit. Yes,
I can see.
I think
that's the logic.
But I think that's consistent, and that's consistent. That's consistent. That would be consistent with Article 8.4.
Yeah. Before we leave the text of 7.1b, may I just ask you a question about a word which I think has featured in the respondent's skeleton argument?
Yes.
Just to understand what you say about it. 7.1b talks about not to become a burden. It doesn't say not to be a burden. Is that of any significance on your submission? Because it might be said that may provide part of the answer to the kind of question that we've just been exploring. Because it may suggest that there has to be a causal link between the fact of exercise of free movement rights and the becoming a burden. So in other words, if the situation remains financially neutral or even goes down, then it could be, well, the question is, could it be said that you don't fall within 7.1b because you haven't become a burden? That requires some new event occurring which has a causal link to the fact of movement. Is that a possible way of reading this?
I had understood the word become to be used because the assumption is that someone starts off with some resources, and the test of whether they're enough is whether at some point in the future, before they reach 5 years continuous residence and become permanent resident, they're not going to reach the point of being a burden. Right. So that's, in my submission, it's just simply indicative of the fact there's an assumption that someone has some resources or either capital or pension or what have you that they can point to.
Thank you.
And if they can't point to that being sufficiently robust over the period they're anticipating residing, then they fail the test.
Thank you.
Yes, so are we still on ground one, or is that ground one finished?
Final point on ground one, and which I think is one that we've already touched on, is I do emphasise again that I say this analysis is consistent with and proportionate to the underlying objective of Article 7.1b, and that the kinds of protection that were canvassed by the Court of Justice in Wet Commission in Belgium and Badratari that we looked at are simply not to the point here. In this case, looking in this limited way at the origin of the resources, it is a necessary and proportionate way of protecting that interest. And I do say that it's legitimate to regard the Upper Tribunal's analysis as leading to a potential for bootstrapping, where someone can pull themselves up by use benefits which they happen to be entitled to then generate a right to reside and then generate an entitlement to more benefits. In that context, I briefly want to take you to a case that we haven't yet looked at. I'll do it very briefly, which is the case of A, which is A in Latvia's Republic Veselības Ministrija. Now, this post-dates the end of the implementation period, so it's not binding on you, but I say it's persuasive.
Tab? Tab number?
Sorry. Tab 30.
Thank you.
and it's at page 835 and 836. And the issue here was the claimant was self-sufficient, and the question was whether the Latvian authorities were required, respecting his right to reside, were required to enrol him on the state social security and health system. And rejecting the analysis of the Advocate General, the court said no, they weren't, because it would effectively render Article 7.1b redundant. So relevant paragraphs of 56, condition for residence in accordance with Article Directive 2004-38 would be rendered redundant if it were considered that the host state is required to grant to an economically inactive union citizen residing in its territory on the basis of Article 7.1b affiliation free of charge to the public sickness insurance system. So that would just snooker the requirement for comprehensive sickness insurance. And the court makes a similar point at 62. And in my submission, that's at least somewhat analogous to the position here, where someone is seeking to use state support on the other side of the equation to build up a right of residence on the basis of state support on the resources limb of Article 7.1b. I will conclude my submissions there on ground 1. I just highlight that I don't resile from the submissions at paragraph 48 of the skeleton argument in relation to the S case, but I won't go through those orally. Another point to note is that S is also a case that post-dates the end of the implementation period, which so isn't binding. That's not a point that the judge seems to have noted. And I also, I think most of the submissions at paragraphs 49 to 55 I've already covered off. We've addressed in the course of this morning the point about Dano, correct understanding of Dano at paragraph 76 to 80, which I address at 53 and 54. So I then move on to ground 2. Ground 2 is advanced on the basis that you decide that I'm wrong on ground 1. So this is a ground that we submit that there are a number of material errors of law in the judge's approach to how he assessed that WB had sufficient resources. And I'm going to distill those into a headline point and three main points. The first sort of headline point is that in my submission there is some considerable tension between the idea that one can't look at the origin of resources and then the approach that the judge took to then finding that WV had sufficient resources on the basis of the domestic legislation. He seems to have had regard to WV as a beneficiary of the social assistance, effectively, while at the same time maintaining, in respect to the first issue, that the origin of resources was irrelevant. So my three points here. First point is, and we've approached this already, is that I say that the judge misinterpreted and misapplied Article 8.4. As we discussed earlier, there are two options that a member state is permitted to take in identifying a reference amount. They can identify the threshold for eligibility for social assistance, or where that's not applicable, they can look at the amount of state pension, state social security pension that's paid. The judge seems to have gone for the latter approach, despite the fact that the UK implementing regulations go for the former approach, eligibility threshold, but then with a backup individualised assessment in order to render it a lawful reference amount. So to say that the support is sufficient because it's the amount that the Secretary of State has determined is appropriate for a couple in their circumstances, in my submission, not to the point. I had to look, and the suggestion that my learned friend makes, that effectively the judge was engaged in an individualised assessment, is in my submission misplaced. Clearly, looking at the question of what is the global general threshold, and has misidentified it. So that, in my submission, is an error of law. And indeed, the level of income or capital that a couple may have in order to exceed the threshold will differ from the amount that they may actually be paid in benefit. So our submissions on this are set out fairly thoroughly at paragraphs 58 through to 61 of the skeleton argument.
Yes.
So that's the first difficulty with the judge's analysis. The second point, and that's independent of the first point, is one that I've already alluded to, that there is a fundamental tension between taking account of when considering whether the resources available by way of social assistance payments were sufficient for the couple, taking account of the fact that those resources were calculated by reference in part to V being a member of the household, but on the other hand, maintaining that the origin of resources was irrelevant. If the, as it were, if the screen comes down at the point of saying, well, these are resources of J's, they're the resources of a family member, which is permissible in light of the case law, and one can't go beyond that and ask about the origin of those resources. In my submission, that's simply not consistent with the approach the judge then takes in looking at whether the resources were sufficient. The third error in the judge's approach is his approach to the position of J. We've already touched on this when I was going through the directive. We accept that J wasn't a beneficiary of the directive, but in our submission she didn't need to be. That's clear on the face of Article 7.1b, which refers to resources of the EU citizen and their family members, and she squarely qualifies as a family member under Article 2.2. Indeed, in my submission, it would make a nonsense of the requirement in Article 8.4 for the member state to consider sufficiency on the basis of the personal circumstances of an EU citizen if the fact that he had also had a family which was going to need to live off any resources that they had, if that was to be ignored.
Does it follow from your submissions that, as a matter of EU law, this couple are required to live in different member states? Because presumably Belgium would make exactly the same kind of argument if J tried to go to Belgium to try and live with him there.
Yes.
Yeah.
Yes, it would be a matter of a member state taking a more generous approach than is required under EU law.
Yeah. Yeah.
But it does follow that there is a restriction on
Husband and wife living
husband and
together.
wife. Yeah. Yes. If they're not economically active and don't have sufficient resources, I mean, unless one came up with some argument about charter rights or something, but on the face of it,
and your submission, I think, is this right? That will follow, even though if each of them live separately in each of their respective states of nationality, each of those states bears exactly the same financial burden.
yes,
Yeah.
yeah. I mean, that's in my submission. That's just clear on the face of the clear face of the directive. I mean, it's the burden in the host state.
Yes.
And if they live together, one or other state is going to be a host state.
Yeah.
Somebody.
What do you say to the point that that's all a bit odd and arguably inhumane? For what legitimate public purpose is being served by insisting that a married couple must live in two different states rather than together, where there is no, on my hypothesis, there is no financial burden being imposed on either of them beyond what they each would have to endure if they do live separately?
Well, I think the argument would be that it's a matter for the member states, it's a matter of their domestic law. I mean, ultimately, it's about the position of the host state national. They want, for understandable reasons, they want to live with their spouse. It's a matter for the member states, a matter of domestic law, how generous or not they're going to be in relation to that, having regard to their own policy objectives.
Yes.
But as a matter of EU law, I mean, EU law isn't the only sort of tool in the toolbox. But as a matter of EU law, one goes back to the fundamental point that the Advocate General made in Traiani, that if you're not economically active and you need welfare support, the idea is you get that in your home state.
Yes.
Whether it's odd or not, it's that in my submission is an obvious natural consequence of the EU's free movement law. Yes. So. We say that on any sensible reading of sufficiency of resources, account had to be taken of the fact that any resources would need to be sufficient for both V and J to live. And I point out in my skeleton argument at paragraph 66 that there seems to be a curious consequence of the Upper Tribunal's reasoning, that you could have different outcomes depending on whether or not both partners were EU citizens, or whether one was an EU citizen and one wasn't. Both could have exactly the same resources, and one could be self-sufficient, satisfy Article 7(1)(b), and the other not.
But, I mean, this is written with curious consequences we've just been discussing on, where
yes,
you accept one of the outcomes is that a husband and wife in a genuine marriage should be driven to live in two separate countries. So,
yes, I mean,
odd, curious.
So that brings me on to ground 3.
Thank you.
So this is again on the basis that you're against me on everything so far, and that V did have a right to reside as a self-sufficient person, and then the question is whether an unreasonable burden would be imposed by him continuing by him receiving universal credit. We say there are a number of difficult errors of law in the judge's approach. The first one is we submit he looked at the wrong periods in respect of assessing burden. In my submission, it is really a matter of common sense that if one is asking whether a burden in relation to one period is reasonable or not, it's entirely appropriate to have regard to a burden that has already pertained and one that may pertain in future. And clearly, in this case, as to the first of those burdens, there has already been a period when Mr. Versnick was, to some extent at least, a burden on the social assistance system of the UK. The argument in relation to the subsequent period is perhaps slightly more complex. The judge's reasoning here was that it was known that Mr. Versnick would obtain settled status after 23 months, and at that point he would have a right to universal credit, because that is a qualifying right to reside. I make several points on that. The first one is that it misses the point. The fact that someone becomes entitled to universal credit doesn't stop them being a burden on the social assistance system. It is still therefore relevant to ask to take that subsequent period into account. And on the judge's findings, there was no evidence. He found there was no evidence that Mr. Versnick would actually engage in employment or self-employment. And in that context, it would be reasonable to look at the period of any dependency as exceeding beyond the 23 months. And contrary to the judge's analysis, this isn't actually an issue about pre-settled status. It's an issue which would equally arise straightforwardly under EU law. If the judge is right that Mr. Versnick could maintain his right to reside as a self-sufficient person, notwithstanding receiving universal credit over that 23-month period, that would mean that he would be able to have clocked up 5 years residence under Article 16 as a self-sufficient person, both in the period before his claim and the period thereafter. So in my submission, the judge's focus on pre-settled status at this point is neither here nor there. And it's a problem that would arise simply even if the UK had adopted exactly the approach set out in the directive when it set up pre-settled status.
It's my fault, I'm not really understanding. Why is the question of sufficiency of resources of any significance at all once he has indefinite leave to remain and his right of residence isn't dependent on resources at all?
It's legally not significant in relation to the future period because there's no requirement that he not be an unreasonable burden on the social assistance system once he has permanent right of residence.
Right. So
that's I said. But the question is in relation to the period before that, i.e. the period between the Secretary of State's decision and when he acquired settled status, is that burden a reasonable one or not. And in my submission, it's relevant to that question to ask, does that burden arise in the context of a period of previous burden and potentially a period of subsequent burden?
Well, can I just take it in stages? Can we just do subsequent?
Yeah.
Subsequent burden. Why is subsequent burden when he has a full right of residence relevant to the reasonableness of the burden before then? I'm just not quite following it. It's my fault, I'm sure.
Well, I think if you pose the contrary position, you're looking at two scenarios. One scenario in which, on the judge's findings, there is a period from his arrival in the UK in 2017 up to the Secretary of State's decision when he has a right to reside as a self-sufficient person, and we say there's a burden on the social assistance system.
Sorry, you go on.
Then there's this intermediate period, which the judge was focused on, 23 months, and then there may be some further period. Now, in my submission, it's relevant to assessing the burden of that, the reasonableness of the burden of the intermediate period, that it could potentially become part of a period of burden of 5+ many years, potentially unlimited years. And the fact that the Secretary of State might be obliged to bear the burden after he has settled status doesn't change that position.
Can I just follow on from that? Is it right? I don't know the answer. Is it right when someone has a right to reside in this country, either because they're like the wife in this case, living here, or they assume a right to reside after 5 months, and they are entitled to social assistance? Is it right to refer to that as a burden? Well, I'm just a bit worried about that. I haven't seen burden described. I just feel a bit uncomfortable that we, citizens who are entitled as of right to social assistance, that we're just all happily referring to them as being a burden.
Yes.
Whereas my understanding is the idea of the burden is that someone that comes to this country and imposes themselves, and I'm not using legal language here, just colloquially, imposes themselves upon our social security, social assistance state, are a burden.
I think the answer is that I entirely take my lady's point, but the way in which the directive itself and the Court of Justice seems to use the term burden doesn't necessarily carry that pejorative connotation. It simply means...
I'm sort of drawing a distinction between those people that have social assistance as a right because of their, and those who would not be covered by Article 7.
Yes, I think I'm not sure that's the way, because if one goes back to the way that the court defines social assistance in paragraph 61 of Bray, and the concept of burden seems to be built into that. And obviously there will be lots of people who are perfectly entitled to social assistance, and there's no pejorative suggestion, but that seems to be I mean, elsewhere the EU legislature refers to recourse to the social assistance system. I'm not sure whether there's any intended difference in meaning. That might be a more attractive.
It feels very different, doesn't it?
But given the way, I don't think that the court uses the term burden necessarily to align with rights or not. Because the question,
so you quite deliberately, picking up Lord Justice Popplewell's point, refer to an as of right claim to universal credit post a 5-year period as a burden.
Yes, understood in that non-pejorative.
hope I've not taken you off course.
No, I'm.
And we have your submissions in writing on this.
Yes,
don't we?
you've got my submissions in writing. I'm just checking. On the point about just two other points while we're talking about the period. The first is, I know my learned friend suggests that this is really just nitpicking on the facts, but the judge takes the same approach to the relevant period in the case of VB that I referred to. I'll make sure we have copies of that tomorrow. Takes the same approach and regards the approach, seems to regard the approach as being one of identified point of principle. Second point is that the 23-month period that is identified has to be viewed in the context, as we saw from Bray, of a particular focus on temporary difficulty. And the temporary difficulty is in the context of a maximum of five-year period when someone might be seeking to rely on Article 7 rights, after which, if they've complied with the conditions, they will have the right of permanent residence. And in my submission, a 23-month period in the context of 5 years is not, on any sensible view, temporary. Unless temporary simply means not indefinite. And in that sense, the Roman Empire was temporary. Yes.
That last submission does appear to invite this court to take a different view. I can see earlier arguments you've made. You've suggested there were errors of law. Is this an error of law, or is this simply an irrationality argument?
Well, I think it is an error. It is an error of law. If the recitals to the directive refers to temporary difficulties, and one is thinking about a 5-year period, I think this court, as a matter of law, is entitled to say, well, hang on a second, that's not really temporary, is it? It's a substantial chunk of it's.
I understand why you put it that way, but before we can correct the error of the tribunal, I think you have to invite us to say that it was not in law open to the judge to reach the view that he did.
Yes, I would say 23 months out of 60 is not in context. Yeah. I'd say he failed to consider the provisions of the directive properly in context, and that context is a 5-year period when we might be relying on Article 7. My lady, you've got my written submissions. I'm going to stop there, I think. I suspect I will just be regurgitating points that you have in writing. I don't resile in any way from any of them. Can I just turn my back briefly and check? Unless the court's got anything.
No, thank you very much indeed. Yes, Mr. Royston.
My lady, my lords, I've noted a number of the questions that the panel have put to my learned friend, and will, as best I can, deal with most of them along the way. There was one relatively straightforward point that I thought it might be helpful to handle before I get into my submissions, which is what the role of this court is. It occurs to me it might be helpful for the court to have overnight sections 13 and 14 of the Tribunals, Courts and Enforcement Act 2007, because that deals with the basis on which you're entitled to allow an appeal, which, as my learned friend says, is if there is an error of law. It's a pure error of law jurisdiction. And that's section 13. And then section 14 explains what you can do if you detect an error of law. So you can, but you don't have to, set it aside if you detect an error of law, and then you can either remit or remake the decision that the Upper Tribunal made.
Well, that'd be helpful, thank you.
I'm sure we can liaise to make sure that that's put before the court. So I have three headline submissions, and I'll broadly attempt to follow the structure of my skeleton. I suspect I will deal with the first of them, which is ground 1 and the longest ground today, and then probably 2 and 3 tomorrow morning. The first is that we say that V did have sufficient resources between June 2017 and the 28th of July 2020, because nothing about the source of these resources mean that any or all of them need to be disregarded. That's the crux of ground 1. In response to ground 2, we say the Upper Tribunal was entitled to find that the level of these resources was sufficient. And then finally, in response to ground 3, we say the Upper Tribunal was entitled to find that from July 2020, the claim for additional social assistance in respect of V represented a reasonable burden for the UK. Before I address ground 1, I want to highlight for the court 3 factual findings, I think all uncontroversial, which I'm going to attempt to show over the course of all of my submissions are critical to this case and its outcome. Number 1, V's entry into J's household reduced the amount of social assistance being paid by the UK social assistance system in the period 2017 to 2020. It did so by £46.85 a week, £203.2 a month. So in the counterfactual scenario, where V hadn't moved to live with J, that period would have generated greater expenditure for the UK social assistance system. Fact 2. Throughout that period, 2017 to 2020, V and J had to live on as much as UK nationals would have received in the same circumstances. I should have given you, as I say, I very much hope that all of these 3 facts prove to be uncontroversial, but I should give you the reference as I go. So the first is para 14 of the Upper Tribunal's judgment, Core Bundle 79. The second I derive from paragraph 48 of the Upper Tribunal's judgment, Core Bundle 91. And my final fact is that for the period from 28th of July 2020 to 16th of May 2022, so that's 1 year, 9 months and 18 days, the total amount of extra social assistance at issue, and by that I mean the difference between what V and J got and what UK nationals would have got, is £80.09 per week, £347.07 a month. And I derived that from paragraph 70 of the Upper Tribunal's judgment, Core Bundle 98. I'll refer back to those 3 facts during the course of my submissions. So I'm going to move now to tackle ground 1. And I want to make...
So that's the difference between what they got and what other UK nationals would get.
Yes, that's right. And that's the amount of money that this appeal turns on, because if the Upper Tribunal's judgment is upheld by this court, the Secretary of State will have to pay to V&J that additional amount. £80.09 a week. So on my submissions about why nothing about the source of these resources mean that any or all of them need to be disregarded, I want to develop my submissions in 4 parts. First, I'm going to submit that it's necessary to look very carefully at what the legislative test is, not to gloss it. Secondly, I'm going to do something which my learned friend hasn't so far addressed in his submissions, which is to go back to the basic principles of EU citizenship law and to submit that when in that area of law, it's necessary to justify a limitation on a right of residence, not to justify the grant of a right of residence. Third, I'm going to submit that a flaw in the Secretary of State's arguments are that when referring to the desirability of protecting public finances generally, the Secretary of State is conflating one of the high-level aims that motivated the legislation, so the Citizenship Directive 2004-38, is conflating that high-level and somewhat abstract aim, which exists alongside a number of other aims that the legislator is pursuing, and then a second thing, which is the conditions that are actually prescribed by the legislation. Fourth, then, and finally, after taking the court through those 3 preliminary points, I'm going to submit that by reference to the wording of the legislation, the authority on the meaning of the legislation, and then from first principles, by reference to practicality and to the principles that underlie the directive, there is no relevant limitation on the resources which V could have taken into account in this case. I very much hope that I'll get through all of that today. I may be able to also deal with the distinctions between social assistance, social security, and special non-contributory benefits. I hope actually that explaining that rather complicated area of law may ultimately prove a fairly uncontroversial exercise, and it occurs to me that there's probably some extra materials that we can put in overnight that will assist the court in dealing with that. But if I have time, I'll make some submissions.
Well,
about
let's
that as well.
see how we can get.
I'll see how I go.
Right.
So,
Legitimate test. Legal test, sorry.
yes. So at several places, both in written submissions, so for example at paragraph 45 of his skeleton, and in oral submissions, the Secretary of State uses language like, in order to establish that an EU citizen is a burden. Now, the court put this to my learned friend, and I don't accept that gloss on the legislative language. I wonder if the court could turn up Article 7, which is Authorities 183, tab 8. I do, as my Lord Justice Singh pointed out, place weight on the use of the word become in 7.1b. Have sufficient resources for themselves and their family members not to become a burden on the social assistance system of the host member state during a period of residence. That is supported, the significance of become in that article as more than just surplusage is supported by recital 10, and if the court turns back to 171 you'll see it. Persons exercising their right of residence should not, however, become an unreasonable burden on the social assistance system of the host member state during the initial period of residence. In my submission, what that shows is that by virtue of the EU citizens' presence in the UK, something must be at risk of changing for the worse for the UK social assistance system. My Lord Justice Popplewell, in my respectful submission, was right to link the interpretation of Article 7 to its purpose. And so I want to take the court very briefly to 4 of the cases which address that. First, Darno, tab 24, page 633, para 77 of the court's judgment. And the word that I invite the court to note is in the penultimate line, it's create. The requirement, the link established by the Union Legislature in Article 7 of the Directive between the requirement to have sufficient resources as a condition for residence and the concern not to create a burden on the social assistance systems of the member states. Next, Garcia Nieto, tab 27, page 716. The relevant paragraph is paragraph 45.
So page
716, my lord.
and paragraph
45.
Thank you much.
And here, it's the first 3 lines of that paragraph that I invite the court to focus on. As Advocate General Wathelet observed in point 70 of his opinion, that provision is consistent with the objective of maintaining the financial equilibrium of the social assistance system of the member states pursued by Directive 2004/38. And there's an express reference here to Recital 10 as reinforcing that, which is why I took you to Recital 10 along the way, as is apparent in particular from Recital 10. The next reference is in Bray, page 576, tab 22, paragraph 61, and it's in the middle of that paragraph. An individual who does not have resources sufficient to meet his own basic needs and the needs of his family, and who by reason of that fact may become a burden on the public finances of the host member state during his period of residence, which could have consequences for the overall level of assistance which may be granted by that state.
I'm not sure that necessarily helps you as much as the other passages, because what this is attaching significance to is a different causative question. Whereas I think the earlier ones, you were entitled to make the submission that a causal link is required with the exercise of free movement rights. Whereas what this one is about is the reason of the fact is that you don't have enough money. That could be true even if you haven't moved.
Well, that may be so, my lord. The point that I'm attempting to draw the court's attention to here is the reference to the, in particular, the culminatory part of the passage that I read out, consequences for the overall level of assistance which may be granted by that state.
Yes, I see.
So a concern about systemic consequences of granting a right of residence. I think I'll maybe think about it, overnight, but I think I agree with your lordship that it's not so focused on my point, but I do say that I derive assistance from that.
Yes.
And then finally, Bajratari, tab 28, page 743, paragraph 37. Here, the court is analysing the problems that are caused for a member state by allowing somebody to rely on income from unlawful work, because that's what the court said you can do in this case.
By which page is this now?
743, my lord, and paragraph 37.
Thank you very much.
Where the resources available to a union citizen minor to support himself and his family members during his period of residence in the host member state is derived from income obtained from employment in that member state occupied by a parent who's a third country national without a residence card and work permit, in the light of that parent's precarious situation due to the illegal nature of that residence, the risk of a loss of sufficient resources and of that union citizen minor becoming a burden on the social assistance system is greater. So again, there's a concern for the systemic consequences for the social assistance system. In my submission, that's a consistent theme, and it does link the purpose of the measure and the interpretation of the measure, in my submission, in the way that Upper Tribunal Judge Ward interpreted it. Now, a key question in this case is whose social assistance is being talked about. Now, as the appellant's skeleton at paragraph 27 notes, quoting the Advocate General in Trajani, I think you've been taken to it already. The reference is para 70 of the AG's opinion, and it's at tab 17, 415. But my learned friend cites it in his skeleton. He says, the basic principle of community law is that persons who depend on social assistance will be taken care of in their own member state. Now we say continuation of payment to her that she's been entitled to by right since her...
Sorry, forgive me, but what is your answer to the question you've posed as to whose social assistance we're concerned with? Is it that of the individual migrant, or is it the individual migrant and family?
It's the individual migrant, and the social assistance in this case was not for the migrant, it was for the UK national. She was being paid in her own member state, completely consistently with that principle. Continuation of that payment can't possibly disturb the equilibrium of the social assistance system. The Secretary of State says that on an analytical approach, using the language of the directive, J, because she's dependent on social assistance is a burden. Now, as my Lady Justice King points out, that's striking language. She suffered a spinal injury in 2004. Before that, supplementary bundle para 73, there's evidence of her working from the age of 14. After her injury.
Supplementary bundle page?
73. Subsequent to her injury, she's extremely severely disabled. She gets the highest rate of personal independence payment, which is the non-means tested social security benefit that provides support for people with high levels of care and mobility needs. So she gets the highest level of the care element, the highest level of the mobility element because of the severity of her condition. When she was on ESA, there were 2 levels of that as well. What's sometimes called the work-related activity group, and there's the support group. And she was in the support group. She was in the minority of particularly severely disabled people. She's got a right to claim those benefits. That's what the benefit system is for. The Secretary of State said, and I entirely accept, the Secretary of State is making her submissions from the perspective of her view of the legal interpretation of the directive. Is not doing it in a way that's intended to insult or demean my client. The Secretary of State says, well, that's not meant pejoratively. That's very difficult to reconcile with the Secretary of State's concession in oral argument earlier, that burden in the directive means unreasonable burden, by reference to recital 10. It's my submission that social assistance provided to a UK national is incapable in law of being an unreasonable thing for the member state to provide, and therefore it is incapable in law of being a burden. I propose to move now to what I said was going to be my analysis of how the fundamental principles of EU citizenship law bear upon this case, because in my submission, that is important. This court has been faced with my learned friend, to his credit, facing up to the striking consequences of his argument, separating husband and wife, even though that generates no extra cost to either, even though them living together would generate no extra cost to either member state. Secretary of State says that flows from the directive, and that any possible remedy would have to lie in the hope that domestic law, either here or in Belgium, would be more generous. My submission, the Secretary of State is inviting the court to, and I'm stealing a phrase from my learned friend here, to look through the wrong end of the telescope. It's repeatedly suggested in the skeleton argument that it's implausible that a person's dependency on welfare benefits could be a basis for a right of residence. So 2 references I noted were at 47 of his skeleton and paragraph 3 of his skeleton, where it's called surprising. In my submission, there's a fundamental difference between domestic immigration law, which does not have as its starting point that foreign nationals have any residence rights here at all, and EU citizenship law. And of course, it's important to remember that this country took a democratic decision to leave the European Union, very substantially motivated by concern about the obligations of EU law. We're dealing with a historic situation here. The question where an EU citizen is concerned is, in my submission, not is there something about this situation which justifies giving them a right of residence, but is there something about this situation which justifies taking away the fundamental treaty right? And I'm going to show you the fundamental treaty right in a moment. I do just briefly, in light of my learned friend's submissions about the potential for other parts of law, whether it was human rights law or purely domestic law, to just flag up to the court that the uncontroversial principle that EU law is read in light of fundamental charter rights. Two in particular present themselves as relevant here. The Article 7 right to private and family life, which is a parallel of the Article 8 ECHR right, and the Article 9 right to found a family. So the root of EU nationals' residence rights in other member states is in the TFEU. It doesn't sit in the directive, it's in the TFEU. I think I will ask you to look it up. Tab 6, page 163. Now, I've never quite understood why Article 20 and Article 21 appear to include such repetition. I suppose my bad jury point would be that it's so important that they felt they had to say it twice. But Article 20, as after in subsection 1 establishing citizenship of the Union, then at 2A provides the right to move and reside freely within the territory of member states. And then at the foot of Article 20, over the page at 164, these rights shall be exercised in accordance with the conditions and limits defined by the treaties and by the measures adopted thereunder. And then Article 21.1 says basically the same thing. Every citizen of the Union shall have the right to move and reside freely within the territory of the member states, subject to the limitations and conditions laid down in the treaties and by the measures adopted in effect. We then move into the Citizenship Directive. I wonder if I could ask you, I've shown you recital 10, but I wonder if I could ask you to look at recital 11 at 171. So this is tab 8. Just in case there was any doubt, this is a principle that's been repeatedly stated by the Court of Justice. The recital explains that the fundamental and personal right of residence in another member state is conferred directly on Union citizens by the treaty. I then just briefly want to show you one of the, because we're going to look at Article, or the crux of this appeal is Article 7, which includes some of the limitations. I want to show you another of the limitations that the Citizenship Directive imposes, which is in Article 27. That starts at 203 and runs over the page. And you can see that here, license is being given to member states to restrict freedom of movement and residence on grounds of public policy, public security, or public health. Perfectly unobjectionable, and then there's further down in Article 27 provision for how that shall be addressed proportionately and fairly, and there are a number of procedural rights that a person who's subject to an expulsion decision can benefit from. So that's one of the limitations. Article 7 includes another of the limitations. And there I hope I've done enough to illustrate my key point here, that Article 7 isn't the creation of a right, it's the limitation of a right that exists because of the treaty. The reason I'm telling you this is because EU law also has something to say about how limitations and fundamental rights are to be construed. And the Advocate General's opinion in Commission and Belgium gives quite a helpful explanation of this. Paragraph 33, which is 459, tab 19. So tab 19, page 459, paragraph AG 33. I'd invite you to read the whole of that paragraph, which runs over to 460.
I think I've noted the wrong reference. Can you just give me that again?
Page 459, my lord.
Yeah, I have.
AG 33.
Thank you.
And so the key bit is over the page on 460. The fundamental right merits a broad interpretation, and the corollary of that is that the conditions to be attached should have a highly restrictive interpretation. Confining such conditions in the name of the principle of proportionality to the aspects strictly indispensable in order to safeguard any collective values which might limit freedom while not undermining the scope of that freedom. Now, that's a very lucid exposition of the approach to fundamental rights and the approach to limitations and conditions on those rights, lest it be said, well, that's just an Advocate General's opinion, and you can find Advocate Generals saying anything about anything. I want to give I'm not going to take the court to these references now, but I want to give you some references to the Court of Justice saying the same thing for your note. The first of those is that at Chen, paragraph 31, that's on page 447, tab 18. Chen, para 31, page 447, tab 18. There's the court saying construe rights broadly. There's another, on construing limitations narrowly, there's another good explanation of the importance of that by Advocate General Tizzano in Chen, which is a para 74 of the AG's opinion. Para 74 on page 435. And then the court itself says it in at least 3 places that I've found. Bray, paragraph 70, that's tab 22, page 577. Bray, para 70. Bajratari, paragraph 50, tab 28, page 745. 745 Bajratari, paragraph 50. And then Camberaj, paragraph 86. That's tab 21, page 539. Page 539, Camberaj, para 86. So when approaching what Article 7 means, it's necessary to recognise that we're not looking for a reason to give a right, we're looking for a reason to take a right away, and we're doing so in a highly restrictive way. Article 7.1b imposes two conditions which I would characterise as broadly economic conditions, remembering that the public policy conditions aren't permitted to serve economic ends. Firstly, you have to have sufficient resources for yourself and your family members not to become a burden on the social assistance system of the host member state during your period of residence. Secondly, you have to have comprehensive sickness insurance cover in the host member state. Now this takes me to my third point on ground one, which is to suggest that when the Secretary of State makes quite broad-ranging submissions about public finances generally, about welfare benefits generally, she's conflating high-level aims that motivated the legislation and the actual conditions that are prescribed by the legislation. The Secretary of State says it's surprising that someone who has lived entirely on the host state's welfare benefits has a right of residence. Well, I don't entirely accept that characterisation, and I'll say a little bit more about that later on, but I don't accept that it's surprising, because what the Secretary of State has completely failed to demonstrate is any link between denying a right of residence for that 2017-2020 period and any adverse consequences for the equilibrium of the UK social assistance system.
But can I, I'm sorry to interrupt you, but these are all submissions in favour of your headline submission, as I understand it, that it's not permissible to take account of the source, the ultimate source, at all, even if that is. And that's a separate point from the point you make, which is on the particular facts of this case, there was no additional burden created. Now, I'm not understanding so far how anything that you've said, and I thought I ought to say this so that you can focus on it in relation to this submission, how anything you've said leads to the conclusion that if the indirect source is social assistance, that is simply out of order, because it would seem to me to follow, but I may be entirely wrong about this, that the consequence of that is that your submission depends entirely on the mechanics of how the social assistance is paid. So if for example, to simplify it, suppose that you have a system in which a single person gets half of what a couple get by way of social assistance. And in one country, if it's claimed, it is all paid to one person, in our hypothesis, the national. And in another system, it's paid 50% to each. Does it follow from your submission that in the first system there is Article 7 doesn't bite, but in the second system it does?
I think I'd like to think about that before I give my final answer, because it's an important question, my lord. What I immediately observe is that there in two cases is good evidence for the court saying, well, up to a point, how a member state chooses to arrange its systems is a matter for it, and we're simply concerned with whether there is an extra burden. So, and in fact, it's worth saying that in this case, the facts of our case 2017 to 2020 arose under what's now called the legacy benefit system. These precise facts wouldn't have arisen under the universal credit type system. And Upper Tribunal Judge Ward commented on that in his refusal of permission to appeal. So my hesitant answer, though I think it's something I'd like to think about overnight, is that if, when a state has designed its system, the effect of a person's residence in the UK is to impose a burden on that system which wouldn't be there otherwise, then they will have a sufficiency of resources problem, at risk of being a burden subject to any issues about the reasonableness of that burden.
Sorry, so in those circumstances, Article 7 can be engaged?
Yeah. And there is...
So I'm sorry to press you.
No.
And that is so if the burden arises indirectly, because there's an increased burden. So if in this case it were the position under the legacy situation that directly as a causative result of the exercising
there was more
residence rights, there was more paid to her.
Yes.
That would engage Article 7, would it?
Yes, I think. I'm slightly reluctant to commit myself because I just want to think through a little bit more the implications of that. What this reminds me of, though, is a case that we haven't looked at.
Sorry, if that is right, and I understand you want to
Yes.
think it through, but if that is right, how do you square that with your headline proposition that indirect source is irrelevant? Because it's all come immediately from her. In the factual scenario I've been putting to you, it would still come immediately from her to support him, albeit that it was funded by an increase in the burden on the social assistance.
Well, I think what there's a... Yes, let me address this right now by reference to a part of Darno that I was looking at over lunch, which is page 633. I took you to paragraph 77 a little earlier, the concern not to create a burden on the social assistance system of the member state.
End of paragraph 77.
Yes. It's probably 78 to 80 that are more relevant here. At 78 and 79, what the court is saying is not in terms that you should disregard social assistance that's caused by entitlement to which is caused by the presence of an EU national. What it's saying, if you look at 78 and 79 in isolation, is that if you made a member state grant those benefits, then such a person would be able to say, I automatically, the term used at 79, have sufficient resources. And so, for example, before 2004, this country didn't operate a right to reside test in the social assistance system. So an EU national could, in the 1990s, there was a habitual residence test introduced that effectively produced, it stopped benefit tourism stricto sensu, in that you wouldn't be able to receive benefit until you've been in the country for a sufficient period in many cases. But it wasn't until 2004 that it was necessary to demonstrate a particular quality of residence as an EU national in order to have access to social assistance. What the Court of Justice is saying in Darno is a member state has got to be allowed to say we're not going to grant that. And indeed, they, in Darno itself, the facts of the case were that the German benefit system had refused social assistance on the basis that it operated something rather like the right to reside test that we have in the UK. The court isn't actually saying that where a person, or where social assistance is attributable to a person, you should ignore it in deciding on self-sufficiency. And so I can, and this is the slight reluctance I have to make the concession, because you can see how one might argue, well, if a member state decides that it is actually going to give somebody some money, then they are entitled to have that taken into account, because you take a very, very restrictive approach to Article 7, and you don't look at all at the origin of the resources. However, I can see that given the purpose, which is what your Lordship sort of started this line of argument by asking about, given that the purpose is avoiding adding a burden to the social assistance system, I can see how that would be a problem. If you could that would be an example of bootstrapping.
I speak for myself, I'm not sure that 79 of Darno helps you, because the focus at the end of the paragraph is on the grant of the cash benefit intended to cover the beneficiary's subsistence costs. That is to say, it's the benefit that's coming out of the social assistance programme, the burden,
yes,
to cover the beneficiary's subsistence costs, irrespective of who it actually goes to. So that does rather lend support to the idea it doesn't matter what the route is, whether direct or indirect. It's the fact that the burden is imposed,
yes,
because there is an additional grant by reference to the beneficiary's subsistence costs.
yes. Well, and indeed, and so for the purposes of my argument about what Upper Tribunal Judge Ward correctly said is an unusual set of facts, I succeed on an analysis of Article 7, which looks at the
indirect source. I understand that, and that's why I was just wondering. I'm sorry to have interrupted your flow.
No.
There are two possible ways you put your case, and you by and large put it on the headline point, which is indirect source is simply out of the arena. Your alternative point is, if it's within the arena, you look at the overall burden as a result of the exercise of rights of residence. And on the particular facts of this case, the exercise of the rights did not itself cause a burden on the social assistance system. But there are two, I think, different arguments.
Yes,
and as you were going through your list of points, I was just trying to, in my own mind, see which applied to which.
Yes. Well, I found that helpful. I hope that discussion has been of some assistance to the court as well.
I'm sorry, I've taken you out of your way.
Yes, well, this is the point at which I want to turn to some of the Secretary of State's criticism of my arguments in her supplementary skeleton, particularly paragraph 6 to 11 of it. She says that 2004-38 doesn't suggest that a person's engagement in a socially useful function, such as providing unpaid care, so the state doesn't have to, is relevant to the assessment of a right of residence. Well, on reflection, I agree. And the reason that I agree, in my submission, it helps reinforce the central argument on this appeal, which is that the Court of Justice has described in narrow terms, particularly in Bray, what counts as the social assistance system, and that is the sole test that the court needs to focus on. When the Secretary of State makes reference to the policy objective in quite general terms of protecting public finances, they're making the same sort of error in my submission that I was. The legislator had to draw bright lines to turn a number of high-level objectives balanced against each other into a functioning scheme. So, for example, if you had to take into account all drawing on public finances, or all aspects of the welfare system broadly construed, you might have to look at whether a person had children in state education, or looking at the public finances in the wider sense, did they use the council swimming pool a lot? There's all sorts of ways in which all of us have an impact on public finances broadly construed. If you were doing that, you would also have to look at the flip side, which is where is a person contributing? And I don't resile from the factual correctness of my submissions about the role of a carer, because as the First-tier Tribunal found, the unpaid care that V provided was of huge value, and the costs of providing that sort of care, where it's not done by an unpaid carer, fall upon the state. But what I accept is that Article 7 is imposing a lighter touch type test. It's interested in, are you risking becoming a burden on the social assistance system? It's interested in, do you have comprehensive sickness insurance cover? If you're receiving social security as distinct from social assistance, that's not the concern of Article 7. if you're providing super valuable care that's saving the NHS or a council's social care department lots of money, that's not the concern of Article 7 either. But what accepting that I've taken my argument too far helps me show in my submission is that there must be, if the approach is so narrow that it excludes me on one side and the points I make about the valuable contributions, that's an equally good reason to exclude broader, vaguer references to public finances on the other side. It's worth looking at the VI case here, and I'm not sure that the court's been taken to it in detail. I should briefly explain. So VI and Her Majesty's Revenue and Customs, which is tab 31, it is in fact a necessary precursor to why this case is before you at all. Because for some years, and in repeated decisions of the domestic courts, it was held that a person in my client's situation was not off the starting blocks under Article 7 because they didn't have comprehensive sickness insurance. There was some dispute about exactly what that was and what a policy would need to include if commercially procured in order to qualify. But most people who found themselves in the position of claiming benefits didn't have such an insurance policy. They instead used to say, well, if I get ill like anybody else in this country, I'll use the NHS. The domestic courts had said, well, access to the NHS, which EU citizens do have, is not sufficient to meet the Article 7 test. And one can see, from a protection of public finances perspective, a wide perspective, the force of that argument, because compared to the £80 a week that we're looking at for a couple of years here, the potential impact of a migrant's resort to the National Health Service could be absolutely huge in some cases. VI is an important case because the court held that while it was perfectly legitimate, and this was drawing on the Latvia case that my learned friend took you to, while it was perfectly legitimate for a member state to restrict access to its national health system, once it had given that access, that was comprehensive sickness insurance. So the key paragraph is paragraph 69, so tab 31, page 863. It's the whole of that paragraph.
Which paragraph?
69, Mike. I hope, I don't invite you to read it now. I hope what I've done is accurately summarise what that paragraph says, but it's relevant for your note later. So what this shows in my submission is that Article 7 is a narrow, which fits with principles of limitations on rights that I've taken you to already, a narrow and workable approach to establishing whether a person has a right of residence.
I'm so sorry. I'm slow in following the submission. I'm trying to read paragraph 69. I think many people in this country would be surprised to hear the NHS being referred to as a sickness insurance scheme. I mean, that may be legally accurate, but we don't tend to refer to it in that way.
No.
So what is your submission? If V needed access to the NHS, would he have been able to have it?
Yes.
So he didn't, in fact, need to take it. What many people, Bupa sell sickness insurance. He didn't have to have something like that.
No. That was my Lord's question. Summarises very accurately a long line of domestic case law on what it was presumed that comprehensive sickness insurance meant. And as I say, if in this case, the fact that we're here is because the Secretary of State accepts in the light of VI that his eligibility for treatment under the NHS satisfies the requirement of the requirement to have comprehensive sickness insurance cover. So I entirely understand your Lordship's comments. What this shows is that the court was interested not in what the state could have done, because paragraph 69 is very important in saying, they're not saying a state has to do this. It's saying, if it does this, these consequences follow under Article 7.
Right, so is it the position that at the material time we're talking about, which is obviously before this country left the EU, is it the position that the UK did not require somebody like V to have any health insurance, and because
that's right,
he could access the NHS like the rest of us?
That's right.
Right, but what you're saying is that it would be open to a member state to impose such a requirement compatibly with EU law.
Yes.
Right, that's very helpful.
And the UK didn't, and therefore what the court's going to look at is the outcome position, not, and this ties in with the observation that, well, perhaps the social assistance system could be differently structured so as to produce a different outcome in terms of burdens. The court is going to look at, not at what might have been different, but what the actual facts are. And my submission on the actual facts of this case, there's no risk of V becoming a burden on the social assurance system, social assistance system, in that period 2017 to 2020.
Well, in retrospect, there was, because that's what happened in 2020. But
yes, and I don't think it's controversial that the assessment is to be performed sort of prospectively rather than, and there were a number of cases where the Court of Justice talks about, well, there's always a risk in every case, and you, the flip side of that, I mean, that's a principle that cuts two ways, because one of the things that Upper Tribunal Judge Ward says in VP is that it's not open to an individual to go under the radar, keep themselves away from claiming benefit for 5 years, and then say, ta-da, I was self-sufficient the whole time, can I now have permanent residence, please? The judge, in my submission, correctly identifies that you need to look at the position from moment to moment, and if a risk does eventuate, you then assess, well, you are now becoming a burden. Is that an unreasonable burden? And if it is, you lose your right of residence. If it isn't, you maintain your right of residence. The fourth and final part of my submissions hopefully bring these strands together. I say that the Upper Tribunal was right in how it construed Article 7.1b on, firstly, its plain wording, secondly, its application of authority, thirdly, principle of practicality, and fourthly, issue of principle.
So, just before you move on, and I know this is to some extent something that my lord was asking you about, but I just want to get to as I read the judgment of the Upper Tribunal, there are potentially two ways of reading it. And I just want to be clear which of them you seek to uphold. One is a broad reading of it, which is that it is legally irrelevant to ask what is the origin of the third-party funds. So the second, and that's based on dicta in the CJEU case law, which the Upper Tribunal judge appeared to be saying all speaks with one voice, and I must follow it. But there's a narrower reading, possibly, which is how I read his interim conclusion. You remember the passage we looked at this morning, where he seems to focus rather on the fact that there has been no increase in the burden on the social assistance fund.
And it's the latter
Right.
that I nail my colours to.
Yeah.
Paragraph 56.
Yeah.
Yes.
So you say he was right
Yes.
on that conclusion.
Yes, and as my lady says, paragraph 56 provides a helpful summary of that. So I said in my rather stilted submissions to His Lordship, Lord Justice Popplewell, that the sort of stronger conclusion doesn't seem to me to be beyond the possibility of argument.
Yes. Yeah.
But I don't need to go further than paragraph 56.
Yes.
And I can see the difficulties, to put it no higher, with the tension that a more radical interpretation would introduce. So, my first of those 4 points isn't much more than its heading. And the question of my Lord Justice Singh is, in my respectful submission, right when he put it to my learned friend. The wording of Article 7 is straightforward. It could have included exclusionary language, and it doesn't. Secondly...
Sorry, exclusionary language excluding what?
Excluding a person who derived any of their resources from another person's social assistance, regardless of whether that imposed a burden.
Well, that would be a submission that was relevant to the wider point, wouldn't it? But
well,
I'm sorry, I'm not. It's my fault. I'm not understanding. I can quite see that if you're saying resources that come indirectly from the social security system are simply out of bounds as a matter of law, that you would be saying, and look at it, it doesn't say anything about source, and therefore there you are. But I'm not myself. It's my fault. I'm sure. It's late in the day. I'm not sure. I'm not quite sure what it is you say is missing. That would assist the narrower paragraph 56 where you put your case.
Well, I don't say that the Secretary of State needs words read in to Article 7 on a purposive construction. And I suppose the the way Upper Tribunal Judge Ward puts it at paragraph 56 of his judgment does to some extent read some limitation in, because it suggests that if the social assistant, if what you're depending on is someone else's social assistance and that was more because of your presence, that does need to be disregarded.
Yeah.
And he views that as a necessary reading in order to give effect to the purpose of the...
In the submission you just made, you used the word because.
Yes.
I think, as I've understood your fundamental submission, there has to be a causal link between the exercise of the free movement right and the impact on the host member state's social assistance system.
Yes.
And if you can't, if the thing is otherwise neutral, or indeed goes down, then you submit. There's no causal link.
Yeah.
And I think so the way I understood your skeleton argument, whether it's right or wrong, we'll have to decide. But I had understood your skeleton argument to make the submission that the word "become" is of some significance in that context. So it's a matter of textual interpretation.
Yes.
That it could have said "be." It didn't say that. It says "become."
Yes.
And that "become" you submit inherently introduces some kind of notion of a causal link.
Yes.
And that reflects recital 10.
Yes.
Yeah.
And the 4 cases you took us to.
Yes.
Depending on whether you accept they're all relevant.
Yes.
I get all that. I'm afraid I wasn't. It was when it's the what's missing bit that I wasn't following.
I'm not going to take the court through the cases that my learned friend has taken you to already, but I do want for your note to draw attention to a number of features of those cases, because
This is 2 of 4, and how are we doing for time? I don't want to rush you if this is your important...
We're doing okay for time. You might differ, but
how much longer on 2, 3 and 4 is what I'm asking.
I'll have finished that by 4:30, comfortably.
You're happy to sit till 4:30? Yes, okay.
I'm sorry, I had understood that the court intended to sit to 4:30.
It varies. Some people think it's 4:15, some think 4:30.
If the court
4:30 is absolutely fine. On you go.
Thank you. So the reason that I'm going through Chen, Commission in Belgium, Singh and Bajratari is to emphasise the strength of the line of authority. In Chen, the court rejected a submission that the person must possess resources personally rather than use those of family members. That's recorded at para 29 of Chen, page 447. And the court decided that the terms of, it was then the predecessor to the Citizenship Directive, Directive 9364, but in materially identical language. It decided that the terms of the directive required just that nationals of member states have, quote, the necessary resources, and that provision lays down no requirement whatsoever as to their origin. So that's same page, paragraph 30. Commission in Belgium, tab 19, rejected the lawfulness of a Belgian provision which required evidence of a legal link between the provider and the recipient of resources. The court again held, citing Chen, that there's no requirement as to the origin. It identified that freedom of movement needed to be interpreted broadly. So para 40, which is page 470, and any requirement as to the origin of resources is unnecessary, para 41. It's worth observing in that case that though that wasn't the litigation of an individual claimant, because it's a case, an enforcement case brought by the European Commission, it was heavily influenced by the treatment of a particular family, and the family in that case simply were identified as relying on support by her partner. That's para 20 of the judgment of 468. The court, now we don't know, perhaps her partner was in receipt of social assistance. The judgment, and I don't think the Advocate General's opinion record anything helpful about that, but the court wasn't concerned about tracing back the resources, and it also identified paragraph 47 of the judgment on 471 that loss of resources is always an underlying risk. Singh is relevant simply because it's the first case in which the Chen line of authority is transported into Directive 2004/38, and it re-emphasises that line of case law at paragraphs 74 to 76 of the judgment on page 686. Then Bajratari, I've taken you to already, and while it concludes at paragraph 42, page 744, that illegal income given to a child can be the child's resources. One thing worth noting is that the court specifically recognised, this is at 37 to 38, 743 to 744, that excluding income of that kind would actually promote one of the higher level objectives. The court says a national measure excluding such income, because it's particularly at risk of being lost, would undoubtedly achieve the objective pursued by that provision. But that wasn't enough to read in a limitation. So it's an exceptionally consistent line of authority in my submission that has persisted through a change in the underlying directive, through the strengthening of citizens' rights that 2004/38 affected and that the Treaty on the Functioning of the European Union affected.
Authority for what proposition? Sorry, I'm not understanding you. No regard to origin at all.
That's right. So what that means is that the limited reading in the Upper Tribunal Judge Ward implies at 56, where he suggests that, well, if there were an extra burden, you wouldn't be able to take that into account, is as far as one can permissibly go. My third limb is practicality. The appellant skeleton at 53 says, if asked how he'd live, V would have said, well, through welfare benefits. In my submission, that's not accurate. He would have given the same answer as the family in commission in Belgium. He'd be supported by his partner. No EU law purpose in a case such as this, where no additional burden is generated by V's presence, no EU law purpose would be advanced by asking, well, where did his partner in turn get her resources from? There is an issue of pure practicality. If a person had some social assistance and some other income or capital, how would one separate them out? It might not in every case actually be easy to answer that.
I understand that submission, but there may be a problem with that analysis, which is that the quantum of the social assistance benefit to be paid to J does appear to be increased because V is also now a member of the household.
I don't accept that, my lord.
Right.
Because the Secretary of State's submission to that effect depends on confusing two separate things. One is a step in the calculation of entitlement, and the other is entitlement. As Upper Tribunal Judge Ward said in his judgment, it doesn't make sense to strip out one part of the calculation where his presence is adding to the applicable amount, but then ignore another part of the calculation where his contribution to the household income from his entitlement to carers allowance is reducing the entitlement. The only entitlement to social assistance is the actual sum of the SA that she was paid.
That I understand. I was simply querying your submission that the answer V would have given if asked that question is exactly the same as the family in the Belgium case. I query that simply for this reason, that he might, if he was to give an entirely accurate answer, he might have to say, and the amount that my partner is getting is increased by my presence in the household.
But I'm sorry, this is my fault, my lordship. That isn't correct, right, because the amount that his partner was getting was decreased.
Well, it depends on what you look at.
If you look at, she would have received a decision notice.
Yes.
And the decision notice before he was in the house would have said you're entitled to X pounds of ESA a week. Right. And the decision notice after he arrived would have said you're entitled to Y pounds of ESA a week. And Y was smaller than X.
Yeah. But the global sum was?
The global sum of social security plus social assistance was slightly larger.
I see. Right.
And was that essentially the effect of the fact that previously she was getting a care allowance in relation to care which would have to be provided by others,
she was getting
and
she lost.
Now he was getting the care allowance because he was going to be the carer, which had to be brought into account, but it was more for him than the allowance that she was previously given by way of care allowance. Is that really what accounts for the difference?
That's broadly right, yes. So she was getting a part of an element in her social assistance reflecting that she had significant care needs, extreme care needs, and didn't have a person meeting them. Once you have a person meeting them, you lose that element of social assistance.
Right. So that's why that element in fact goes down.
That's right. So the aggregate, so the total amount of social assistance that she was receiving dropped. Yeah. The only figure that went up was the total amount of welfare benefits.
Yes, I see.
And that includes his social security, and we'll certainly be looking at that tomorrow, and also some benefits of hers, which are social security rather than social assistance. So
well, if we look at paragraph 14, the table there, it says J ceases to be entitled to the sphere disability premium within her applicable amount. Without his presence, it was £66.95, and she loses 66.
That's right.
So that's what came off her ESA as a consequence of you moving in. The care allowance that he got is social security, not social assistance.
That's right.
So not applicable.
And that's and because the carer's allowance is more than £46.85 a week,
it went up.
Total amount of welfare benefits goes up a little bit, but the amount of social assistance, and so the burden on the social assistance system caused by him entering the household, drops. Finally, and extremely quickly, the principled reason has hopefully emerged already. Answering whether someone has become a burden to a system means, as a matter of logic, just as a first principles point, asking what difference is this person making? If the money is going to V anyway, the fact, forgive me, to J anyway, then the fact that she passes some of it to V makes no difference to the system. My final point on the reason of principle is that one of the systemic concerns that one sees repeated through the case law is the concern of benefit tourism, when a person comes to another country in order to receive social assistance. That's Darno and Alamanovich, Garcia Nieto. There's a useful discussion of that in the Advocate General's opinion in GV, tab 33, page 937, 141 to what paras 141 to 143 of the AG's opinion. Looking at the risks of benefit tourism. This is not that case. But to get right back to the very start of today, the reason he came to the UK wasn't to live off this country's social assistance system, the Belgian national, and if he needed social assistance, could receive it there. It was to live with his wife, enjoy family life with his wife, and provide extremely useful care for her. That's a completely different class of purpose than the benefit tourism purposes that are the concerns of the Court of Justice about limitations on citizenship rights relate to. Just as a matter of principle, this isn't the sort of case where abuse of the system is at all plausible. There's a distinct air of unreality in thinking that the access to benefits played any motivational part in the decision-making of the human beings involved in this case. So I have some submissions to make tomorrow morning on the differences between social assistance and social security, and then some considerably briefer points to make on grounds 2 and 3, but I think I'm more or less where I hope to be at 4:30. I apologise for it not actually being 4:30 anymore.
At all. Thank you very much indeed. Very well, everybody. Thank you all very much, and we'll see you at 10:30 tomorrow morning, please.